in school, and it would drive us crazy. But I do want the icebreaker that'll get us talking. So, Mr. Jones, you want to be the icebreaker? Tell me this. Natural. If you're going to be judging whether somebody did, you'd like to hear both sides, right? All right. Now, here's the problem with that. All of us would. I mean, I'll raise my hand to that myself. The judge is going to tell you that the decision whether to testify has nothing to do with whether the man is guilty. It's going to say you can never consider it. And in fact, if you start talking about or thinking about it as having anything to do with whether the defendant is guilty, it's a mistrial and we try this case all over. Because what the law has said is, it's the obligation of the government, when they seek to take anybody's liberty, they have to let their case stand on its own. And they have to convince you beyond a reasonable doubt, regardless of whether he puts on anything or anybody. He has to convince you beyond a reasonable doubt, this prosecutor does, regardless of when it happens to me. Now, it's possible sometime, and I will only say this if I privately think he's got to testify. I'll never commit that he's going to, but if I've privately decided it is, I might say, it's possible that he testify, but let me tell you something right now. That's going to be our decision. That's going to be our recommendation, our decision. He's going to follow our advice. If I don't think the state's proved their case, I might very well say, let's shut it down, let's go home. You're not hearing from me. He's not guilty based on what they didn't show you. On the other hand, it's possible that when he gets on the stand, or when the case is over, we decide to put him on the stand. The operative word there, Mr. Wilson, is we, not him. So, judge is going to tell you he has a constitutional right not to testify, and if you how many of you think that you'd hold it against him? There's a rule that I used to try to, not used to, still follow. I want to ask them open-ended questions about their attitude before I start telling them where that attitude is wrong. Because if I tell them what is wrong, if you start out saying, the defendant has the right not to testify, et cetera, and then you start asking them how you feel about that, you've already loaded the deck against yourself unnecessarily. So what you want to do is solicit their opinion first, then tell them what the law is, then go back and see how they feel after you've told them that. It's just a sequence that I'm comfortable doing, because I always want them to volunteer stuff to me before I've told them they're wrong or the law won't allow it or they have to consider this or that. So it would be, how many of you feel that way? Why do you feel that way? You tell me. I just want to hear both sides. I'm not thinking about punishing him. I know, but here's the thing. And then, how do you feel? How about you? How about you? I'll let them talk about it. And here's the thing I want y'all to remember is, I think lawyers make a big mistake if they think a juror is saying something out there during jury selection that might be harmful to their case. They love law enforcement or whatever. The inclination of a lot of lawyers is to shut them up and get them up to the bench so they're not poisoning the panel, right? I strongly disagree with that. A juror out there is not going to poison that panel any more by saying what he's saying during jury selection than the prosecution is when they're putting on their case. So what you want to know is what they think. So if you've got some juror that's saying stuff that's bad for you, you don't want to shelter the rest of the jury from it. You want to find out how many other people feel the same way. So if that juror says something, I don't want to try to stop them and correct them yet. I want to know if it's harmful to us. I want to know how many others feel that way. How many of you feel that? And if you don't get any, come on. Really? And if somebody says, no, you don't get a response to, how do you feel about him not testifying? You then say, well, how about you, Mr. Smith? I mean, I didn't see your hand in there, but come on. It's 2019. You want to know what everybody, the other side of both things? I mean, you're like everybody else, right? Are you telling me that you're not going to sort of harbor some suggestion in your mind as to whether he's guilty if he doesn't testify? Just stay with him on it. Then, after you get what there is, then you say, now let me explain why the law is that way. And, if you give somebody a constitutional right, would you agree that if you punish them for exercising it, you just took away that right? So we need to know if you can follow the law. The judge is going to tell you, you cannot consider the defendant's failure to testify as evidence of any guilt whatsoever. So you got to make your decision totally aside from that. You understand that, and you do. And then at the end of it, I want to go by row again. I'd go individually if I've got time. I'd just go from left to right. How about you? If this case is tried and you're a juror, and the defendant, lawyers, we decide not to put him on the stand, are you going to hold that against him? Are you going to be able to say, okay, I wish I'd have heard it. I'd like to have heard it, but I got to put that aside. The real question is, can you put aside that desire to hear both sides if the law tells you that's what you got to do? And I need to know whether you can follow the law in that respect. I would spend a lot of time on them if that is an issue in my case. The presumption of innocence, again, we treat it, everybody talks about it real bad. They just go into it. I think it's a tremendous, tremendous thing to spend a lot of time on, similarly what I just talked about. When you talk about the burden of proof, I think that's a tremendous advantage. I think we as defense lawyers, all too often, we walk our way through these things, but almost like they are the stuff in a contract that is just talk and no listening. But the burden of proof is incredibly significant, that all of y'all know, and I think you've got to spend a lot of time on it in jury selection. The same way. Look, he has got to satisfy you beyond a reasonable doubt that he committed this crime. How many of you think, well, maybe he did it. He didn't put any defendant on, any witnesses on. I think maybe he did it. It was a bad crime here. He must have done it, so the states proved their case. How many of you feel like you'd be inclined that way? And when they say no, just stay with them. Keep talking to them about it. So how many, once you think you've explored it enough within the time and amount you had, say, all right, now, there's not going to be a definition of reasonable doubt. We used to have one. There used to be one written out, and the court struck it down. So, reasonable doubt is going to be a doubt when you apply a reason to it. It can't be a gut feeling, can't be an instinct, can't be a coulda or a shoulda or an oughta. It's got to be something that you're satisfied with in the most important events of your life. That's the way you got to look at it. Because it's not your life, it's his life. His life is what's in the balance here. And to take away his liberty or convict him of being a felon or of any crime, you've got to be convinced beyond, I always say, all reasonable doubt rather than just reasonable doubt. All reasonable doubt. And then you talk about this stuff you usually do. One of my views of what I talked about before, lawyers not listening. How many of y'all have tried cases where you see the witness for the state, in this case now, say something that just begs to be explored, but you're not sure what the answer is going to be, and it doesn't fit your outline? Yeah. What do you do? There you go. That's a great answer. That's true. That's the advantage the prosecutor has in taking chances, because he's had investigation and the resources of the state. And if he or she is prepared, they may know more about the case, or they may know some things you don't know. All right? So you're right. That's why they can afford to take chances more than you can. So then, when you're on the defense side and that happens, in my view, it comes down to how well you know your case, how well you know your facts. And is something that witness said not make sense? If it doesn't make sense to you, my inclination is to not run from it and find out what it is. But it's dangerous. You got to always be willing to recognize that's what you're doing. But whether it's direct or cross, and I have to admit, cross is my favorite part of trial. Always has been, always will be. But on direct, and to a certain degree on cross, I'm listening to it as sort of like a two-headed deal again. just like I talked about jury selection. I'm looking at it in terms of one side of my brain is listening to it as what I call the talk show host that listens, and the other side is listening to it, how can I demonstrate or show this to the jury? As we get more and more in love with different types of electronic equipment and putting stuff up and graphics and all, it's easier to do. I want to talk about that in a minute, and then I'm going to quit and take questions because I'm taking a lot of y'all's time. But the talk show host that listened is born when a few years, maybe 2 or 3 years after I started prosecuting, I was asked to be interviewed on a TV show. It was the first time I'd ever done it. And the reporter would ask me a question, and so the camera, you're the reporter, so the camera's on you when you ask me the question. And then it's my turn to answer, and the camera goes to me. It's not on you then. And you start looking down for your next question. You're not looking at me while I'm answering. And it's the most discomforting thing in the world. You just need to go through it once. I'm talking to the top of your head. You're not showing any interest in what I said because you've got a list of questions you're going to ask come hell or high water. And the camera's not on you, so you're looking to do the next one. You'll see it a lot on TV. It's incredibly poor, but lawyers do it too. Next time you got time to watch somebody, if you go watch, you'll see lawyers a lot of times. So they will ask a question, and they'll be looking down while the witness answers. That's horrible. That's horrible to do. Imagine if you're nervous enough as a witness, and then the person asking questions not really listening to what you say, they're waiting to answer you the next question. It affects the spontaneity and everything about it. So I started talking about the talk show host that listens, and that is the talk show host who actually looks at the person he asked the question and listens to their answer. And the other side of the brain demonstrated is what I'm calling the jury side. What about that witness is saying would help me show? I mean, I've demonstrated all kinds of things in trials that didn't occur to me until the moment it happened because of what the witness was saying. I can remember one time trying to recreate a moment of horror for a woman, and I didn't tell the bailiff, which was my mistake, and she was raped in a car. And I know these examples, so many of them are prosecutor examples, but I don't think they have anything to do with prosecution or defense. It's just the kind of circumstances that happen. And so I wanted the jury to feel the terror she felt. So when it got time to talk about it, she's raped in a dark parking lot in a car as she's getting in, and he rapes her in the car, and he was a serial rapist. And so when it got time for her to leave the house or leave her apartment to go in the car, and it was pitch black dark, without warning anybody, because I just thought of it I went over and turned off the lights. Well, it just about gave the bailiff a heart attack, okay? As you can imagine, all of a sudden he's got a guy charged with following, and now it's just darker than hell. And so I learned always to warn the bailiff after that if I was going to do something, if I would think about it. But the same thing with a pickaxe into a phone book. I buried a pickaxe in this guy's chest, and he left it there. That's the way, actually in the woman's chest, and they left it there. So I got to talking. This is back when you had yellow pages, big thick phone books. You don't have them anymore. And so the axe had been introduced into evidence. And so the phone book was about that. And it occurred to me to take the axe and with the mouth that had been described, after she described it, into the phone book. Well, that also gave the bailiff a heart attack. And you need to also tell about that. But it happens. What you need to be doing, though, is thinking about, if you're listening, you got to have the freedom of yourself to listen and act on it. And I've always said, a trial is like your living room. The witness is somebody that was invited into your living room, and you want to get information out of them. Well, you wouldn't ask leading questions. That's the biggest. First evil is asking. The first evil is not listening. Second evil is asking leading questions when you're really trying to get information out. And so I ask a lot less leading questions in cross than everybody teaches you. I want to know. I want to get the witness version out. I want to get the witness talking to me. I want to get the witness what they're going to say, and then you want to start contradicting stuff later. But you may, when the other side puts a witness on, when the state puts a witness on cross, first of all, cross is showtime, all right? Because particularly on the defense side, you do much more cross than you do direct exam because you may not have any witnesses, okay? Which is why testimony and all that stuff before and no witnesses is important in jury selection. But cross is when you get to be imaginative, but you can only be imaginative if you're listening. And so I know resources are there, but if you get a law clerk, I don't really want to be the one taking notes because I have a hard time listening and taking notes at the same time. So get a law clerk, anybody, doesn't matter. Have somebody taking notes for you if you can find them. And because I want to sit there and just listen. And all of you's memories are good enough to remember what the witness said if you listen. And because that's a short-term memory deal, right? It's not a long-term memory deal. I don't remember anything about a trial once it's over, but I have a pretty good memory while it's going on. So I want to listen, and then I want to assess that witness. Is that witness lying? Is that witness telling the truth? Is that witness telling the truth, but they're mistaken in terms of what hurts my part of the case? Is that witness talking about something that they know something about, but it doesn't have anything to do with my client or my client's participation? I'm spending the first 5 or 10 minutes of cross trying to decide who they are. You're always nice on cross to begin with. You never beat up on a witness until they have earned it in front of a jury. If you have a police officer or other witness that you have private bad feelings about and think they have not shot straight, or some witness or so, the jury doesn't know that yet. You don't come out of the box challenging them and going after them. You get them talking. You get them to get to where the jury can have a feel for what they're like.